We had a goodie in the Floyd v. Vegas case yesterday, and it was the defendant LVMPD's response to plaintiff's motion to extend time to respond to motion, ECF 14, which I went through the other day. Defendant Las Vegas Metropolitan Police Department, by and through the Attorney of Record, Marquis Urbach, hereby files its response to plaintiff's motion to extend time to respond to motion. Memorandum of Points and Authorities. 1. Introduction. On July 16, 2023, defendant LVMPD filed its motion to preclude Jose de Castro from practicing law without a license and to strike plaintiff's complaint as an improperly filed pleading. Generally, LVMPD's motion requests an order precluding non-attorney Jose de Castro from practicing law without a license by assisting Mr. Wallace in this lawsuit and striking Mr. Wallace's complaint due to Mr. de Castro's involvement. On July 21, 2023, Mr. Wallace emailed LVMPD requesting an extension to respond to LVMPD's motion and threatening sanctions. Exhibit A. Within 20 minutes of receipt, LVMPD agreed to Mr. Wallace's request and informed him he could file an unopposed motion or as a stipulation and order. Just switch down to Exhibit A and you can see the exchange of emails. So, firstly, Floyd Wallace wrote, "Dear Craig Anderson, will you oppose a motion for an extension of time to respond to your motion to strike my complaint? In order to allow you the full 21 days to withdraw it before I file sanctions." And Craig Anderson responded, "Hi Mr. Wallace, thank you for the email. I am agreeable to extending the time for you to respond to the motion to strike and motion to dismiss. You can do it as an unopposed motion or you can draft a stipulation and order. How long do you want? Best, Craig." Mr. Wallace never responded to LVMPD's email and 3 days later filed his current motion to extend time to respond to motion. Mr. Wallace requests until August 15, 2023 to oppose LVMPD's motion. Although Mr. Wallace should have ended his motion at this point, he chose to include a limited opposition to LVMPD's motion. Ironically, the limited opposition provides further evidence Mr. de Castro is drafting Mr. Wallace's pleadings. Legal argument. A. LVMPD has no objection to Mr. Wallace's extension request. As stated in LVMPD's July 21, 2023 email to Mr. Wallace, LVMPD is agreeable to extending the time for Mr. Wallace to respond to LVMPD's motion. LVMPD also unilaterally agreed it would extend Mr. Wallace's deadline to respond to LVMPD motion to dismiss. However, Mr. Wallace did not take LVMPD up on the offer and has filed his opposition to that motion. Therefore, LVMPD is agreeable to extending Mr. Wallace's response deadline to LVMPD's motion to August 15, 2023. B. Mr. Wallace's limited opposition provides further evidence Mr. de Castro is unlawfully assisting him. According to Mr. Wallace, LVMPD's motion has no factual basis because no factual assertions are supported by a declaration or affidavit, and the attached document has no verification. According to Mr. Wallace, Federal Rule Civil Procedure 75(d) prohibits LVMPD from correcting any rule violations in its eventual reply. First, Mr. Wallace's reliance on Federal Rule Civil Procedure 75(d) is problematic. This rule was abrogated in 1997. Second, there is a local rule in Nevada requiring the submission of an affidavit with the filing of a motion. A federal court that does have local rules requiring the attachment of an affidavit to a motion is the District Court for the District of Massachusetts. Interestingly, Mr. de Castro just lost a lawsuit in Massachusetts, subject to those local rules. See de Castro v. Abrams. In short, it appears Mr. Wallace is relying upon the federal rules of Massachusetts, a jurisdiction where Mr. De Castro recently litigated and lost. Thus, Mr. Wallace's motion to extend either provides further support of Mr. De Castro's assistance or is simply another coincidence. Third, Mr. Wallace represents LVMPD has no supporting evidence for the motion to preclude. Mr. Wallace knows this representation is false. The day following Mr. Wallace's arrest, Mr. Wallace and Mr. De Castro went to the LVMPD substation. As both Mr. De Castro and Mr. Wallace filmed their interactions with a sergeant, Mr. De Castro clearly says, "I am going to assist Floyd in suing you guys." Thus, evidence exists from Mr. De Castro's own mouth. Mr. Wallace was standing within 5 feet of Mr. De Castro when he made his announcement, filming. In addition, Mr. De Castro has recently uploaded several videos bragging he has filed 2 lawsuits against LVMPD. A search of the record establishes Mr. De Castro has filed only 1 lawsuit under his name. Conclusion: based upon the above, LVMPD does not oppose Mr. Wallace's extension request. Now, as you can see from the response, they could have ended it on the final paragraph of the introduction, and it's although Mr. Wallace should have ended his motion at this point, he chose to include a limited opposition to LVMPD's motion. So they could have ended their motion there, but they chose to further ram it down the court's throat that Mr. De Castro is assisting Mr. Wallace in his motions in his LVMPD lawsuit. Thanks for watching.